Hello, everybody.
All right, the court next calls the matter of Bethany Rose Osborne versus Mark Joseph Armstrong. This is file Osborne, file 23-19403 DM. And Mr. Osborne and Miss Osborne, go ahead, present.
Present.
Okay, welcome. You are Mark Osborne, correct?
Yes, sir.
Okay, welcome. And Miss Osborne, are you with us?
Yes, I am.
All right, so we're here on a status conference. That's just really for me to follow up to see how things are going. The unfortunate thing is that there's been some difficulties with communication, and what I mean by that is this case, obviously, when I had you in front of me before, I referred you to mediation. When I refer you to mediation, that first goes to the mediator's office. They then reach out to both of you. It sounds like the mediator's office was available for mediation, was able to get a hold of you, Mr. Osborne, but they could not reach you, Miss Osborne. So did you get a new phone?
I spoke to the mediator's office in the beginning when they were trying to set something up, and she gave me a price. And I told her I wasn't sure if I could do that because I was in between jobs. I was getting ready to start my new job. And I never received an email from her after that, or if I did, I lost my phone, so I've kind of been locked out a lot of my stuff, but yeah, I told her that if it was going to be $150 for each of us while I was starting my new job before I got my first paycheck, I couldn't afford that.
Well, have you started your job now?
Yes, I have.
Okay, are there still issues that you think you need to have resolved between you and Mr. Osborne?
Resolve?
Absolutely.
No.
There are a lot of things that I have written down. Communication with Bethany is non-existent, and that is why on our last court hearing, I asked and requested for mediation because a lot of the stuff has not been resolved. And like I said, communication with Bethany is non-existent.
Well, Ms. Osborne, that's a problem in this fashion. I understand what you're saying is that, money's always an issue. And when you were just starting a job, that you didn't have it, and if you had an issue with your phone, all of those things are understandable by me. But the issue is that it's not just Mr. Osborne that's saying there's a lack of communication, it's our mediation center, and they don't do that. I don't think I've ever seen that letter before. But their statement to me is after talking to both parties who were willing to set up mediation. However, I was unable to reach Bethany Osborne after 9/19 of 24 to confirm a mediation date. Our offices tried reaching Bethany, by phone and email, and both are out of service. So there can't be mediation. You can't set up a date. And I've already told you in general, the way the court operates is I'm not going to set aside docket time, generally speaking, to have the matter resolved by me if you haven't made a good faith effort to resolve it yourself first. So from that background, can I presume now that you are working, now that you have a phone, that now you're willing to get back into communication with mediation services?
Yeah, but I got locked out of the email that they were trying to communicate with me. So no, there would not have been any communication with that email or that phone number. The phone got lost. I got locked out of everything. I was not able to sign in because I could not validate my password.
Ms. Osborne, I'm assuming that you've been able to have communication with those people you've chosen in the last 60 days.
Yeah, and there's been plenty of communication with Mark, so I'm not sure what he's referring to because unfortunately there's been plenty.
Ms. Osborne, I'm not talking about communication with Mark. I'm talking about communication with community mediation. I ordered the case to mediation. They were trying to get in touch with you. It's been 60 days since you've been talking to them. I'm saying those things only to remind you of the fact that the mediation referral was a court order that you helped agree to so that I can find out if there are actual issues that I need to resolve. And if there are, I will. But I'm reordering the case to mediation. Now the barriers that were in place apparently previously have been remedied. You have a phone, you have the ability to connect, you're doing so right now. The mediation number I can provide you right now if you want it. That way there's no question about it. So tell me when you have a pen.
Give me a second. Okay,
There's two different numbers, so I'm gonna provide them both. The telephone number is 989-732-1576.
okay.
If you need a fax number, I can provide it. Did you just need a telephone number, or do you also need a fax number?
Telephone number is fine.
Okay, so can you read that back to me so I'm sure that you got it?
989-732-1576.
Yep, that's it. So, Mr. Osborne, can I presume that you have the phone number for mediation services? You're obviously still willing to mediate.
Yeah, I just wrote the number down, just to verify, 989-732-1576.
That's correct. So they will reach out to each of you again. It's my requirement that you go to mediation. It is absolutely not my requirement to reach an agreement there. But the point of mediation is that two things. It allows you an opportunity to discuss with somebody else who's not involved in the case, keeps emotions in check. And number two, it helps to have the issues clarified. I'll at least know more specifically what the issues are. So I will bring you back here in about a month, and hopefully you're able to get in to see the mediator in that break in between now and then. Thank you both for your time today.
Yep.
On the record in the matter of the state of Michigan versus James Lamar Duncan II. Appearance, please.
Good afternoon, Your Honor. George and Ed, Assistant Public Defender, on behalf of Mr. Duncan for purposes of arraignment only this afternoon.
Thank you. And you are James Lamar Duncan II with your hood on in court?
Yes. Yes.
Thank you. Okay, today was the date set for an arraignment. I do have a felony complaint here. It alleges that on or about August 30th, 2025, at South Martin Luther King at or near William Street, which is located in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act in count 1 of police officer assault, resisting, obstructing. And that's also the charge in count 2. As to count 1, it alleges that you committed the assault, batter, wound, resist, obstruct, oppose, or endanger Officer Haven Hyatt. And as to count 2, it's as to Officer Derek Selden, both police officers of the Lansing Police Department, that the defendant knew or had reason to know was performing their duties, and that this was in violation of Michigan Compile Law 750.81D1. Both count 1 and count 2 are felonies. The maximum penalty 2 years and or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement or for another violation arising from the same transaction. There's an habitual offender second offense notice. It says, take notice that the defendant was previously convicted of a felony or attempt to commit a felony, and that on or about July 15th, 2015, he was convicted of the offense of carrying concealed weapon in violation of Michigan Compile Law 750.227 in the 30th Circuit Court for Ingham County. Therefore, the defendant is subject to the penalties provided by MCL 769.10 that enhances your penalty to 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges read, the maximum penalty, and the habitual offender second offense notice, sir?
Yes.
Okay, you have the right to be represented by counsel. Mr. Annett is only here to represent you because you're being arraigned today. You have the right to have an attorney to represent you at all of your court appearances, and a right to attorney to represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the public defender's office screen you for representation for free. You understand that, correct?
Yes.
You have the right to remain silent, and anything that you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way to a jury trial. You're being charged with 2 felony counts. You have the right to preliminary examination within 21 days unless you waive that 21-day timeline or the court finds good cause to go beyond the 21 days. At the time of the exam, you have the right to require the prosecutor establish that they have sufficient probable cause that the felonies were committed, and then probable cause sufficient to charge you as the person who committed said felonies. You understand that?
Yep. Yes.
You're scheduled for probable cause conference before Judge Tony Flores, September 11th, 9 o'clock in the morning. You have preliminary examination before Judge Flores in person at the court, September 18th, 9 a.m. Did you receive notice to appear?
Yes.
You have the right to the presumption that you are innocent. So you're innocent until proven guilty. You can require that the prosecutor prove your guilt by taking this matter to jury trial, and they would have to prove each element of the charges being brought against you beyond a reasonable doubt. You can maintain your silence at trial and not have silence be used against you, or you can waive silence and testify. You have the right to present evidence or subpoena witnesses to trial that will testify on your behalf, and the right to see, hear, and question any witness called to testify against you. Do you have any questions about any of those rights?
No.
You have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Is he requesting the public defender's office?
Yes, Your Honor.
The court will enter a plea of not guilty on your behalf. Are you employed, sir?
Yes.
Where?
Employed with third party to GM.
What's your home address?
Lansing, Michigan, 48911,
What's your phone number?
6606.
Are you on probation or on parole?
Oh,
Do you have any other criminal cases pending?
no.
Counsel, you can address bond.
Thank you, Your Honor. I would ask the court to consider a PR bond at this time. Mr. Duncan has a very limited criminal history from what he reports to me. The charge within itself, it's not clear whether it's assaultive in nature. Your Honor, as the court knows, a simple direct no response could lead to a felony charge of resisting and obstructing. Mr. Duncan has one child and 2 living with him, so he takes care of 2 children, to my understanding. Based on the circumstances, there's no information given that he's a failure to appear. He has issues with failure to appear to court. He assures me that he'll be to court for every hearing. I'd ask for a PR bond at this time, Your Honor.
Okay. I recognize that a limited criminal history is, I guess, relative. Some people might think it's limited, some people may not. I don't consider his history limited. He's got a conviction from 2010, conviction from 2014, conviction from 2015. He was charged in 2024, but it looks like that was dismissed. And then now he has this case. Oh, he's charged in 2024 on another matter. That was also dismissed. But he has this case, and it's being charged as a habitual offender, second offense notice. So it's not very limited. But this is not a matter that the court believes that a personal recognizance bond is not appropriate. So the court will grant the request for personal recognizance, 1,000 personal recognizance. Your conditions are that you must appear to all of your court dates. You are not allowed to travel outside the state without prior approval of the court. You're not allowed to possess or use alcohol or drugs unless you have a valid prescription. You're not to possess a firearm or any other dangerous weapon, and you must report to pretrial services within 48 hours. Okay, sir?
Okay.
Do you have any questions about your bond conditions?
No.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, sir.
Be safe, be well, sleep sweet, and much love.